The Behavior Analysis Regulatory Board meeting is convening at 9:39 a.m. on January 22nd, 2021 at the Health Licensing Office in Salem, Oregon by telephone conference call. I will now call roll. Brenna Lagarde.
Present.
Brad Hendershot.
I'm here.
Corey Stumpf.
Hello, I'm here.
Marie McMillan.
Here.
Jennifer White. Here. Samantha Parnham.
Here.
And then I'm here, Megan John. Members, when you wish to speak, please state your last name for the record. For the record, public members calling into the public phone line are asked to email April Fleming at april.fleming@chsoha.state.org.us and provide your first and last name. Public and interested party feedback may be heard during the public interested party feedback period if indicated on the agenda. Everyone is asked to use appropriate language, manners, and protocols when conducting board business. This meeting is called to order.
Sorry, I was talking away with my phone or my computer muted. So first item on the agenda is hopefully everybody has the documents, but I'll help since we're not going to be able to see each other. But first item on the agenda is approval of the agenda. If somebody could make a motion to approve other than Megan.
I move to approve the agenda. This is McMahon. I move to approve the agenda. Can someone second that?
This is Brad. I second.
Okay, and then Megan, you have to do a roll call every time that there's a vote.
Thanks for the reminder. Megan John. Aye. Brenna Lagarde.
Aye.
Do I need to call the people that have already put the motion through and seconded it as well?
Yes, you have to go through the entire list every time.
Okay. Brad Hendershot.
Yes, I.
Corey Stumpf. Yes. Marie McMahon.
Aye.
Jennifer White. Aye. Samantha Parnham. Aye.
Okay, so this is Sylvie. We've on the agenda, item number 2, just some reports. So all of you should have the materials that were emailed out. Director's report, just a couple quick little things. We're in the process of getting some new positions filled. So licensing has had several vacancies for quite some time. So she got a couple new positions filled, so they're in training, which is helping because we obviously are still open. COVID-19 is the next subject, and they're kind of go together. Our office is still closed unless you have an appointment, and appointments are for testing only, so that we can continue trying to get individuals licensed. Doesn't really relate to your licensees because they don't have to take an exam. But our office is open, so we are still answering emails and answering the phones and doing all that stuff, but the public just cannot walk in. The other thing is that session just started. Paul's going to talk a little bit about a couple bills in item number 4, and we just had another bill that came out today that I wanted to be able to share with you guys, but that's not going to work because obviously you can't see my screen if you can't log in on the computer. But we'll email that bill out to you real quick so that you can look at it, but we'll talk about that a little bit. So, and then in session, you guys are one of 16 boards and programs that we have. So we get really, really, really busy. And so we've got several bills out there that are adding new programs to us, potentially combining a couple boards. There's another one that's potentially talking about moving independent boards in underneath of us. And so we're awfully busy, but we'll get into some more details very specific about the bills that will specifically affect you guys. And hopefully you received the new materials, because in that Paul included his little write-up, so he's going to do some talking, but we'll get to that when we get there. What else about COVID-19? So we're still Marion County, so we're still at the highest level, so we are not allowed to do certain things, so we have very few people actually at the office. So many of us are working remotely, which was working great until today, and this MS Teams didn't seem to want to cooperate with us. But that's kind of how we all see each other. But other than that, you know, things are just chugging along slowly, day by day. But anybody have any questions on anything related to COVID or the office as a whole? All right. Let's move on. So in your packets, you had some statistics stuff, and I'll kind of go through it. If anybody has any questions, you're welcome to interrupt me and just ask. The first slide shows the licenses issued and licenses renewed, broken out by the different license types. So you can see there that we continue to issue a lot of interventionist licenses or registrations. Speaking of which, one of the bills changes it from a registration to a license. The next slide shows the long-term trend of the number of licensees. As you can see, behavior analyst interventionist is a lot higher than we originally thought was going to be. And then the next few slides are just that same information, but then broken out by age and gender. And I've said this before, I think the orange is because you do not have to identify whether you're male or female. It's a voluntary question. So if they don't answer it, then it obviously gets left blank, and then it's that orange color. But you do have to give us your date of birth, and so it does break out the date of birth stuff. And if you get to the interventionist slide, that one is the one that shows that this is, you know, the majority of these registrants are under the age of 33. So most of them are age 18 to 25. So kind of interesting information. The next slide just shows, as of the date that's on the top of it, which is January 7th, there was 1,471 interventionists, 325 analysts, and 23 assistant analysts. And then the next one shows your financials. And you're going to see there that obviously a lot more revenue is coming in than expenditures, and I do believe that's because we have a lot more interventionists than we ever thought we were going to, whatever we originally projected. And so the fees are set that way. So what I'm going to be working with the budget people and work on a plan to start either lowering fees or offering discounts for certain things. We'll work on that, so that'll be something that'll be coming here in the future. So I'll keep you updated on that. And then the expenses, we're going to go into an executive session, and this will be one of, I do believe, your first big long-term cases, and those start getting expensive. So we'll see how far it goes, and we'll talk a little bit more about it when we're in executive session, but that could potentially increase your expenses.
So nothing.
Does anybody have any questions for me?
Just got it this morning.
And if you do, go ahead.
This is McMahon. I'm wondering, I'm noticing for 2020 that the expenditures were significantly greater than they're about half as compared to other years for revenues and expenditures. And I'm just wondering, are we allowed to get any more detail? I mean, does that relate more to legal costs or incidents? And is there any other information available about why is there such a larger expenditure there?
So are you talking about from going to 101 to 164?
Yes, thank you.
Yes, okay. So no, and we can get those details. I don't have them like off the top of my head, and I don't have them sitting here in front of me. It is, you know, it could be Attorney General fees. That all depends. But it also is it could be part of being a part of public health. So we get an assessment as being part of public health that we, you know, obviously all boards have to pay for it. And so, but we can get you some details of the difference for the about $63,000 in a year.
Yeah. It sounds like it would be relevant to sort of figure out what cost it relates to, especially as we're anticipating potentially long-term cases and Attorney General.
Absolutely, absolutely. So Ann, can you remind me to get the expenditure details for 2019 and 2020?
2019 and 2020, you want expenditure details. Okay, and do you want...
Yep, just a reminder. I know how to do it. I just need a reminder so I don't forget to do it.
Okay, thank you, Sylvie. And just for my information, will that be presented at the July meeting, or will that be a follow-up?
What we could probably do, if there are people who are interested in it now, is that I can finalize it, and then Ann can send it out to you, and then we can talk about it at the next meeting.
If that works for the board, I'm happy to do that.
Yeah, we'll do that. So Ann, just make sure it's included in the next board meeting also, so they can have it in advance, and then we can talk about it in the board meeting some more.
Got it.
Any other questions for me before we move on to the regulatory report?
This is Ann, Sylvie. Sorry to interrupt. The bill that we were going to share, Senate Bill 710, because of our technical difficulties, I went ahead and I downloaded it and had April email that out to board members. So when we start talking about this new bill that came out, Senate Bill 710, you'll be able to look at it and follow along.
Perfect.
Thank you.
Hi, good morning. This is Bob. And I've got the regulatory report. And as of January 22, 2021, the 17-19 biennium, we had a total of 13 complaints received. 3 remain open, 10 are closed, and I believe we're going to be talking about a couple of them later today from that biennium. And then in the 19-21 biennium, we've had a total of 24 complaints received. 13 remain open. 11 are closed, and I think we're actually going to talk about a couple of those today as well. Any questions? Moving on.
Okay, so board members, Ann, if you would want to get in front of the camera, well, I guess Marie's the only one that's going to be able to see you, but if you could get in front of the camera, that'd be great. Mm-hmm. So at the last couple board meetings, and you can add to all this, you guys had talked about restraints. And so there's a lot of information in here related to restraints. However, that bill that Ann was just talking about also talks about restraints. So I'm thinking if you get in, and hopefully you guys have read those materials, and we probably shouldn't spend too awfully long talking on about it if we're going to go to the, Ann?
Yes?
You're sharing your screen.
That's okay. I was going to pull up. I thought we were going to talk
Okay,
about...
you're on mute.
Help me out.
You're unmuted. So
Ann, you're sharing your screen, and you're on mute.
That's okay. Hi, everyone. This is Ann. Do you want me to talk about the proposed rules?
Well, and that's kind of what I was thinking. So hopefully you guys have read through those materials that Ann included. And then she also has in here a proposed rule that I think will cover us until we know if this bill is going to pass. Because I think if that bill that talks about restraints passes, then we'll have to readdress this. So I know Ann emailed you guys the bill, so I know nobody's probably had time to read it. But does anybody want to have a discussion about restraints?
Thanks, Sylvie, if you can hear me now. Thank you all for your patience today. At the last meeting, just to follow up on what Sylvie said, we were expecting everyone on the board to send us some homework, information about restraints, and the information that we talked about sort of came after the meeting, so that's why I included it with the materials this time. There's a lot there. A lot of it are abstracts. I know we talked about, Sylvie suggested perhaps having an administrative rule that says if your place of business does use restraints, to have some sort of policy in place that you can share with the parents or guardians of the clients. And so to that end, we put a little proposed rule together, which we can talk about or we can back burner until we find out what's going to happen with Senate Bill 710, which just came out this morning, was shared by Paul. It should be coming to you from April, and it essentially talks about, it modifies allowed and prohibited uses of restraints of children in care by child caring agencies, Proctor foster homes, and developmental disabilities residential facilities. Have you guys received, did you guys get on your email and receive that bill?
This is Brenna. Yes, I'm looking it over now.
Of course, of course.
Yeah. This is Brad. Yeah, I'm looking at it too.
Okay. Well, would you like a minute to scan it?
Well,
Yeah,
I have
this
a
is
question. I'm sorry.
Go ahead, Brad. Go ahead.
Well, what I'm trying to do is I'm trying to connect the relevance or the authority, I guess, of Senate Bill 710 and the impact it would have on the work that behavior analysts are doing in clinics and homes and other settings, and RBTs as well. I mean, does it essentially govern or impact their work?
So yes, so there's if you look at page 7, it's got, and I'm just reading this now, but it has a very specific focus on applied behavior analysis. It looks like maybe in order to be a child in care, you've got to be seen in a center-based applied behavior analysis setting. Maybe. I'm not sure that it applies to services that are, given in a home, like in a family home, which is, odd. But maybe makes sense. It looks like it applies to foster homes, but it wouldn't apply maybe to services. For example, my kid gets in my home.
And this is Brad. If you had to kind of characterize this in a nutshell, is it kind of along the lines of restraint is only permissible in cases where the child's safety or the safety of others are in jeopardy and other interventions are not feasible? Does it got that kind of framing to it?
Yes, it absolutely has that kind of framing to it. So the only thing that I think is going to be, so I think the only issues that are kind of out of touch with or inconsistent with what we've been kind of thinking. Again, as I just kind of scan this. So first of all, it doesn't apply to in-home care or in-home ABA services, which is kind of an odd omission if we're really worried about this. And then the second thing is you can restrain if it's consistent with a treatment plan, but the treatment plan has to be signed by a physician, it looks like. So, so the treatment plan exemption is, it's got to be a physician's order written specifically for the current situation, in other words. Now, the thing about it is, right, this is a bill, so it's going to go to the legislature and, the sausage making will commence. And it's hard to know what's going to happen to it. I certainly appreciate the spirit of it. but I think, like I would expect BARB, for example, to have, some questions and concerns and, like at a minimum, if there's, like a qualifying AD treatment plan that, involved something that would constitute restraint in here, weren't to be impacted, then, the therapist would have to sign off on the restraint or the treatment plan.
Mm-hmm.
So anyway, I guess my point is, I think my preference would be to go forward with what, we were going to do. And then we can always sort of revisit that if this bill is enacted based on what the bill actually says when it's enacted.
Okay. Other board members, your thoughts?
This is McMahon. I'm wondering if, I'm not as knowledgeable about all of the legal process here, so I'm just wondering, is there, in what is the way that we can help share some of the concerns we have as the bill is sort of moving through, to say, like, here are some of our concerns. We're wondering that it seems that it refers only to child, care centers, but it's not talk about care that may be provided in a home. Does a child's home by default become a care center because services are provided there during the hours in which that? So I'm just wondering what the venue is for helping to advance the concerns that we may have regarding some of the wording that you just brought up.
So this is Sylvie.
This is Brenna. So Sylvie, we'll have concerns of, like, as BARB as individuals, but maybe start, Sylvie, with telling us what we can do as the BARB by way of commenting on stuff.
Right, yeah. So as the board and the office, we have no position on bills. What I can do is basically tell them if they're making language that doesn't fit with our statutes or they're adjusting our statutes in some way, then I can address that. But if you feel like you personally and in your profession feel that something is wrong or something needs to be fixed or it's not addressing something that you think it should, you have every right as an individual and as a professional in that profession to go to legislation and to talk. You just need to clarify that and say, I'm on the board, however, I'm here in my own capacity as a behavior analyst, and here's my issues, my concerns.
Sure.
So you as an individual have that right. But us as a board would only have input and concerns on language that may conflict with some sort of language that we already have in place, statutory. Mm-hmm. So there. Okay. Does that help? Sure. Okay.
It does. Again, Ms. McMahon. So I guess I think since the conversation that preceded this about whether or not we should discuss the restraint was predicated on the passage or not of this bill, and it's unclear to what degree that all of this is relevant to ADA. I'm just wondering if we don't know those things, and it's not possible to know if there are loopholes in that, perhaps it's worth going ahead and having a discussion about restraint, because it's not clear that, all the loopholes are closed in that.
Mm-hmm. So actually, as I read this, I don't think, so it looks like a child, on page 9, a child in care, so this bill applies to children in care. The child in care is a person under 21 years of age residing and receiving services from a child caring agency or foster home, a certified foster home, or a developmental disability residential facility. So I don't think a kid living with his or her parents would fall into the ambit of this. Mm. And it even says that a kid who does live in a foster home or residential facility is not a child in care when the care is provided in the home of the child by the child's parents. Mm. So I think this only applies to foster kids or residents of developmental disabilities, residential facilities receiving ABA therapy. Mm. It doesn't apply to what I'm going to say are most of the kids that are seen by our licensees, for whatever reason.
and this is Sylvia, and it may say that now, doesn't mean that, well, that won't change.
Right.
Yeah. As we know, bills can have every great intention and be worded a certain way, and by the time that they're passed, they're completely different. So we will.
I would say, yes.
We want to make sure we have this. We keep an eye on it. We'll monitor it. All of us should be monitoring it. But knowing that this might be coming forward, what we could do is we could put the rule that we have in place, or the proposed rule that you have in your packet, and then we can open rules back up again if we want to redo them if this passes, and in some way, shape, or form we want to address rules to align with it.
Mm-hmm.
Yeah, I think that's fine. I think that makes a ton of sense. We should do what we're going to do and keep an eye on this.
Yeah, and we can hold on to all the research that Ann did. I mean, knowing that this bill could potentially change, and it could start including all kinds of different people versus just ones that are in homes. Mm-hmm. I think, there's a lot that can happen, and it's a kind of an odd session because all of the session is kind of like what we're doing right now, where everybody's sitting at home and is on the computer. And so I think we'll keep an eye on it, and like I said, it does. Just because we move forward with this rule doesn't mean that we can't reopen rules again as soon as we know what's going on and change them or add to it.
So does that work for everybody?
Sure.
Okay.
Yeah, this is light. I agree with that course of action.
Okay. So, for those of you who are on Teams, if it's appropriate, I've opened up the proposed rule 824-060-0010. Did everyone have a chance to look at number 3, which was a draft that we crafted after the last meeting, kind of based on some of the things that I thought I heard were important to the board. So did y'all have a chance to look at that?
This is Brad. Yes, I have.
Thoughts, Brad?
What? I'm sorry?
This is Brenna, yeah. I looked at it as well, and I'm trying to find it. This is John's. I also looked at it.
Okay.
This is McMahon. I looked at it.
This is Gordon. I looked at it. This is light. I also looked at the materials as well.
Okay. So,
Did anybody have any issues or concerns with the language that we picked out?
This is Brad. I'm interested in some discussion around the I don't know if problem is the right word, or the issues that we're attempting to address by adding, what problem are we solving by adding this rule language? Or what issues are we trying to head off? And a kind of a related question that I think is somewhat procedural, a wondering that I have is that may need to be, potentially discussed in executive session, but I'm trying to reflect upon the nature, and of course I'm not going to mention any specifics, but I'm trying to think about the kind of complaints that have come into the board and the degree to which they've related to this issue that's sufficient to kind of form a sense of, if there's been a theme or a trend that tells us or would help us identify if there's an issue that the board needs to address. That's what I'm trying to get my head around. Is there, I think it's a general principle. I think it's in the public interest, and it's the interest in children and families to have some guardrails up around the appropriate use of restraints and seclusion. And I know that I'm familiar with the ethics that behavior analysts have to follow, and of course there's other Senate bills and just strict policies and that sort of thing. But I'm just trying to get a sense of what we're trying to head off or address by adding some language. And I guess my final comment before I stop rambling here, is that the one kind of red flag or kind of watch for that's going up when I look at this proposed language is that, we could require that BCBAs and the agencies that employ them have a policy in place, but this language doesn't provide any guidance that I can see around what that language needs to include. Like, I don't see anything around that restraint would only be used in the case where the safety of the child or the safety of another person was in jeopardy, or if other interventions weren't feasible or had been attempted. That's a little bit of kind of a snag for me. So, but anyway, I know I put multiple issues on the table there, so I'll just kind of pause.
This is Ligard. So first of all, to your question of what are we trying to accomplish here? So first thing is we're trying to make it easier for the office to identify and investigate complaints about restraint. Thinking is that if the ABA shop has a policy, and the investigators in the office are free to look at the policy and try and figure out whether restraint's been, a violation of any rules or not, that'll just make it a lot easier and faster to investigate these, very serious concerns. As far as what the rule says, in fact, it doesn't say what the policy needs to say. I think that, and tell me if I'm wrong, right? But I think the ethical rules of the profession state that restraint, can only be used when, the kid is, and certainly the standards of practice indicate that restraint should only be used in the conditions we've been talking about, right? And so I think if you're telling ABA shops you've got to have a policy, their policy will reflect the ethical rules, and hopefully will be clearer, more direct and consistent with the ethical rules. And then the other thing this rule is requiring is that the other need, I think, is to get parents to understand that this is potentially problematic, and that if something happens that they're concerned about, like, they should speak up, right? And so I think requiring ABA shops to give the policy to the parents will highlight those issues and result in, or increase the likelihood that if something concerning happens, we will hear about it because the parents or somebody will complain. So those are the three things we're trying to do, and how I think this, kind of short bit of language, hopefully moves the needle in the right direction on those things. I think that, we could have a, much longer, conversation about what an appropriate policy for the use of restraint should say. I don't personally, I think that gets into a realm of clinical judgment that, is well within, of course, the purview of you all, but not mine. And so I think maybe this fairly minimal approach is something the board can do, something that will make the life of the office's lives a little easier, the investigators' lives easier, without kind of bogging us down in a conversation that is a lot bigger and maybe unnecessary.
So this is Brad. Okay, so I'm understanding that kind of the logic would be, with this language in place, if and when the board receives a complaint of this nature, then in investigating, part of the process would be able to look at the policy that was required to be in place to see the degree to which the restraint was used, whether or not it was consistent with the stated policy, and that policy should be linked back to the code of ethics that these behavior analysts are bound to. Is that kind of a fair characterization?
Yeah, and it's going to be at least consistent with the Code of Ethics, right? The Code of Ethics is going to explain these things in Code of Ethics language, right? And so, one would hope at least that if I'm the Navy Therapy Center, and I'm writing my policy on restraint, I'm going to use simpler, more directed, clearer language about what I want my people to do and what I want, my parents to understand. And then I'm going to put that out there. And then if I'm a parent and something went down that I'm not comfortable with, I might have an easier time understanding that the restraint might have been a problematic part of it. I might then complain, or raise an issue, with the health licensing office with us, and then the investigator can say, well, here's the policy, here's what you did, and so, like hypothetically, right, like restraint could be pretty egregious, could result in bruising or something else, right? Or it could not be. It could just freak the kid out for no good reason. Under those, less egregious circumstances, hopefully a clear policy from the ABA shop will help the investigators and the parents understand what is potentially problematic, and will help the office, flag these kinds of problems for, hopefully make it easier for them to get their arms around what happened and why it was problematic or not, faster and more efficiently.
This is McMahon. Looking at the wording of that, the only concern I have is just the wording of analysts who used restraints. And I feel that, maybe not everyone uses restraints, but I'm just wondering if it's better just to require everyone have a policy in place, even if the policy says, this is not something we do, or, it's within ethics, because I feel that there may be times where you have, if you're not thinking about it ahead of time, that something might get out of control. We need to have more explicit statement and understanding, or that's what we would wish for providers to say, we thought about this, and this is what we're doing, so you don't have a situation in which someone doesn't have a policy in place and something ends up happening. And so it wasn't their intent to use restraint, but restraint ended up happening in the meantime. So that's the only concern that I have with the wording, is that, restraint can be a lot of different things. I think it's better to be proactive and be more explicit in the development of a policy. And so just asking people to be mindful and just state whatever it is for them. So whether their policy is, we flat out don't do it, or here's what we think would, here's the types of things we think might happen.
It makes sense to me. This is Brenna.
This is Lloyd. I would agree with that. It's a good way to kind of plan ahead for something that people may not be thinking about. This is
John. We're kind of seeing, I don't know if this is your experience in the field, right, but ABA therapy centers seem to have these policies. They may not be, the people in the field may not understand them, that our problem seems to be more, like less the lack of a policy and more the, failure to communicate and follow that policy in, cases.
This is John's, and in terms of questions, in terms of the terminology too. So one of the things that I noticed, and it says that licensed behavior analysts and licensed assistant behavior analysts must have a policy and must be given to the parent, but doesn't say the parent has to approve of it, which I think, because I think that should be a consent to services, is if they approve of the emergency, the policy in place, right? If they don't approve, then we shouldn't be using it. And another couple, just semantic stuff, this doesn't include, by licensed assistant behavior analysts, I'm assuming we're talking about the ABAs, not technicians, correct?
This is Ann. That's correct. The way the statute is written, we do not have the authority over interventionists to impose standards of practice and methods of procedures. So it's, also they're supposed to be working for analysts and assistants. So I tweaked the language a little bit to say licensed behavior analysts and licensed assistant behavior analysts must have a policy in place for the use of restraints. A copy of this policy must be given to the client's parent or guardian at the beginning of the service agreement. Brenna and Maria, does that kind of get to what you were getting at?
It does, and I'm also...
I think so.
Mm-hmm.
This is McDaniel. Only, I would agree to some of the last statements that about parent consent, and I'm wondering, they're almost like two related but somewhat separate issues. That on the one hand, you're saying we want you to have a policy in place, and the second regards a treatment plan, right? Like if I anticipate that a behavioral plan is needed in place to ensure that parents consent to the things that are on that you have to have at the time at which you think one will be needed, that you advance a plan that parents sign off of, and so you have consent, because we know that families are vulnerable. They may consent to services at the beginning with not really fully understanding all of the, all the language of what we put in place, the HARES, this policy about, behavior, but at the point in which you come back to saying like, hey, I really think that we need to talk about this, then that's just something that I'm thinking about. Showing up is not always ongoing consent for treatment, and I don't know if people are always attending to that. I think a policy is different than an individual plan, and I think that individual plans, and of course that is best practices that parents sign off on that, but it's a related but somewhat separate issue.
This is Ann. Could you clarify for me? I kind of got lost in the conversation. Is there a desire to have a rule around the agreement on the part of the parent? Or is that, or what you're saying is that agreement part of it would fall under a treatment plan?
My suggestion is that it may be that parents must be part of developing an individual behavior plan for their child, which may or may not include a restraint. Is that reasonable? It sounds like that is something that gets back to the concern of parents agreeing to restraint. But a general policy is different than an individual consent and policy.
So what do our existing rules say about treatment plans and agreeing to treatment plans?
Hold on, get the book.
I mean, so as an ABA therapist, like, I maybe I'm wrong, but I thought that the existing rules get into, agreeing to plan. I'm with you on principle. I'm a little worried about, the perfect being the enemy of the good.
Sure, right.
I do not believe...
We're not, this is really not just like the highest standard, right? Like with a floor.
I was going to say, when we have behavior plans that require any kind of restraint, we have to have parental signatures on board, and it has to be signed off by our ethics officer as well.
Yeah. And I don't know if we're talking about a plan restraint here, or if we're talking about, the day when things go badly, or when, either
right. And that's where
done badly
we have them for if any kid that we think might go badly, or if we know that we're going to use them. Does that make sense? So obviously it happens sometimes if you don't even have plans for it, but for the most part, we have it all already written down, which I think would be ideal. But also, yes, concern with kind of the difficulty of legislating that would be a lot.
This is Ann. Right now, we do not address anything having to do with treatment plans specifically in our administrative rules. Division 60 talks about standards of practice and professional methods and procedures, and we have adopted for behavior analysts and assistant behavior analysts sections 1 through 9 of the 2016 BACB Professional and Ethics Compliance Code. But we do not get down into the weeds on treatment plans.
Hey there, this is Corey Stephan. I'm glad that you just commented on that because it's something I've been just kind of waiting for a good opportunity for. But we do need to make an amendment to the 2016 edition. There is a new 2020 edition. We're probably going to need to change that in our OAR for Division 60.
Well, I have not.
I was going to bring that up
I don't
as well. Do we want to have that be more general to the most current so we don't have to change it every time they update it? Or
This
do we
is
want to
Ann.
keep changing it every time we update
We
it?
cannot do a pass-through rule that just updates automatically. The phrase most current is not acceptable because we need to we need to say very specifically what year, because if we get a complaint, we need to look at when that complaint came in, when the incident occurred, and refer to the exact rule at that time. We can't just say most current, because it doesn't work that way. So if we need to update to the 2020, that's something that we can certainly look at, and I could bring to the board for perhaps the next meeting, and we can look and see kind of how the updated ethics work with what the board would like.
That makes sense. Thank you.
So I think where we're at is, so we're looking at the language the amended language that Ann just proposed.
And honestly, is this still something, we have a few people speaking, but is this something that the board would like to continue to pursue? If yes, how's the amended language? And I can certainly bring the 2020 BACB professional standards to the next board meeting, and that's something that we could look at adopting, get into the rulemaking process with that as well at the next meeting.
Yeah. This is White. Just to clarify, it's 2022 when those new ethical codes will be in place.
Oh, so they're not in place yet?
No.
This is White. We're still on that 2016 compliance code, and then I believe January 2022 is when the new ethical code will be in
Okay,
place.
because I thought it was 2022, and I just had a series of heart attacks when I heard that they were 2020. I'm glad you can't see me because I need to go get the AED machine. I thought it was 2022. Okay, so we're still covered.
Let me tell you, 2021, Ann, was the best year. The pandemic ended.
Oh, keep talking. It sounds like music. Okay, so we're okay.
Everything was magically resolved. Man, that Biden's good.
Okay, so we're still on the 2016 Professional and Ethical Compliance Code for Behavior Analysts, and we're still discussing the proposed rule. Does anyone else have any more thoughts on this? How are we feeling?
Did we come to, or did people have an opinion about have the parent agreement be in the wording or not?
So this is Sylvie. I think this is intended to be much broader, and I think that the parent agreement on stuff would be covered under the BACB stuff. But this is just saying that it has to be part of the service agreement. So one would assume that the service agreement is agreed upon by the parents and the provider.
Okay.
This is Brad. I have a question. Does the BACB Professional and Ethical Compliance Code for Behavior Analysts, does it explicitly speak to restraint?
This is White. I've been looking through the code as we've been talking, and please correct me, anybody. I'm not seeing anything
I'm not either. That's kind of what's raising a little bit of a, I'm scratching my head a little bit because we've got some proposed language that makes reference to the requirement for a policy, but then doesn't provide any kind of stipulations on what that policy needs to include. We're referring back to the ethical code or compliance code, but it appears to be silent on the issue. So,
Yeah,
I don't mean to be facetious. But you could end up with someone having a written policy, and I know this is absurd, but you know, somebody having a written policy that says, you know, restraint is basically what I professionally deem it to be, and that's their written policy, and I don't, you know, and when you have a complaint, you go back to investigate it, it just becomes kind of, I don't know, recursive, like it just kind of loops back on itself in a way that doesn't really achieve the goal. So I don't know. I guess I'm in thought, and I'm not really settled quite yet. But there's something kind of sticking and sticking. I'm getting stuck on something here. I'm not entirely sure what.
Yeah, this is why, and you know, the closest thing I'm seeing really is 4.09, least restrictive procedures, likely to be effective, but that doesn't really cover if somebody were using a restraint when it wasn't needed for the safety of the client or the provider. And so that would be concerning to me.
This is Ann. If it helps at all, there's a second piece of this proposed rule that might give you some comfort in that area. It said the policy that we're referring to about the use of restraints will be one piece of information considered by the board or office in determining whether a restraint used on a client constituted unprofessional conduct, negligence, incompetence, or a failure to conform to standards of practice under 676-612, which is our unprofessional conduct statute. So it seems like it's broad in that it allows people to have their own policies and to follow their own policies. But if a complaint comes in and the office determines that it was negligent or it was incompetent or they were not conform, so that gives us a little bit of kind of closing on that side. Does that make sense, Brad?
Well, I'm just wondering what's the reference point to determine whether it was negligent. You know, what's the yardstick?
Seems like it's 4.09. Least restrictive procedures likely to be effective. I think that's what we got at this point.
Yeah, and this is Sylvie. Brad and Brenna, another thing too to think about too is that it talks about your standards of practice. So what we would do if we had a complaint and it got real complicated, for one, we would hire a subject matter expert, which is a person who is licensed in the field who does not have any disciplinary action against them. But then what we do is we look at, is this the standard that any licensee would consider to be a standard of practice? So just because they have this in place, this policy in place, this is just a tool. It's a tool for us to say, hey, you didn't even follow your own policy. It does not mean it's the only tool that we have. We're going to look at a bunch of other things. We're going to interview the mom, or the dad, any of the guardians, people who were there. I mean, there's a whole lot more to an investigation than this. This is just one piece that says, hey, you didn't even follow your company's policy, so this is an additional issue that you have. Does that make sense?
Yeah. Is there any way of knowing, and again, this might be an executive session type of question, but is there any way of knowing how many complaints have come in since the inception of the board that have related to this issue?
Off the top of our head, that would not be something that we would have right away. We could look into that. Obviously, any details of any cases can't be discussed in open session. I think that this board is a little bit new, and this license type is a little bit new, And it's always good to have something like this in place to kind of cover for things that potentially could happen. Again, rules can always be opened. We can adjust this later and change it later. But this rule does help cover at least one case that I know of, some incidents that occurred in that case. So we know it's needed. I don't know how many cases there are without doing some digging on that.
Well, and I'm just concerned, this is Brenna, like I'm concerned that, well, we're not going to hear about this stuff as it's said. You know, like I mean, this is, as a parent, this is something that keeps me up at night. You know, do I know what everybody who is with my kid is doing? They're not going to tell me. You know, I think there's a general, you know, need to raise at least, you know, parent attention around these issues. You know,
this is
when we, you know, anecdotally, right, there's been issues. It's been very casual. It, you know, it hasn't been treated like the issue I think that it is.
This is Ann. Brenna and other members of the board. With Bob's help, I was looking through section 7.0 and of the BACB code, and it talks about if behavior analysts believe there may be a legal or ethical violation, they have to determine the potential for harm. They have to report the condition to an agency, organization, or regulatory. If a client's legal rights are being violated, if there's a potential for harm, must take the necessary action to protect the client, including contacting authorities and things like that. So Section 7 does kind of get to some of these concerns.
Okay. All right.
This is Brad. There's just a comment I want to draw. There's for some reason, as I think through this issue, the where my mind is tending to focus is I'm thinking about situations in which RBTs are working not independently, but they're working without direct supervision because and just wondering about the degree to which there's a potential gap there. I think in the vast majority of circumstances that's not the case, but that's where my mind is going. Is the times when RBTs are is maybe in the home and the behavior analyst isn't there directly observing. I feel like that feels to me like the context where you might have some increased likelihood of some of these issues coming up, and I'm sorry that I'm not being very articulate, but I feel like this is, you know, part of the dialogue is to try to, I don't know, excavate what some of the issues are. And is that fair? Is that a fair kind of characterization, or is that for those of you who are supervising, directing the work of RBTs, does that feel unfair in any way?
I think it does. This is John's, and it does happen. Like, I know I've specifically told staff when I was working in the home, like, not to use any sort of physical blocking with the child, and I can't always, even though I've told them, and I've told them a couple times, I think sometimes they don't always follow what I'm doing and or what I'm saying. So I think that it is a concern for the families and for the clients of making sure that you know, just an extra component of person.
Right, and we've been having we discuss this all the time with paraeducators that there's a line between a controlling prompt, a physical prompt, you know, to help the child acquire a skill, and restraint. You know, if the child's resisting and you're doing a full physical, well, it's not a prompt any longer. You know, and so those are just, you know, I feel like there's kind of an analogous conversation between working with paraeducators in the schools and RBTs in home and clinical settings. So I'm not trying to divert it. I just.
Yeah, no, I think my personal experience with my kid, I mean, you're absolutely right? And there's you know, there's physical prompting, and then there's, you know, I don't know about this, you know, and we're currently all of this therapy occurs in the home. We're, you know, like, we're very aware of this for a whole host of reasons, but it took us a few years to become very aware of this. And, you know, now very high on my list as a parent is the conversation with, you know, every new therapist about, you know, with every new interventionist about, you know, what's kosher and what's not, and, you know, and then we also make sure that we talk about how, you know, when something doesn't go quite right, like, we're not going to break glass and declare an emergency. Let's have a conversation about it. But we're a lot more proactive than I think a lot of parents are. You know, and the problem is, like, when you have an autistic kid and a toddler, you know, like, you move the toddler's body like you move any toddler's body, and then at some point, you know, the kid's bigger, and it you know, crosses the line into something you shouldn't be doing anymore, and it can be hard to notice that point. So I that's the other reason why I've been in favor of the, you know, the banned language is, you know, I don't really want to impose a rule set, because we're talking about a patient population that spans, you know, a lot of ages. You know, I think what's appropriate for 2-year-olds is really different from what's appropriate for, you know, 16-year-olds. You know, we're not going to get into those differences in this context. And so there are a lot of things that I wish ABA therapists would do, that I wish parents would do, that I wish everybody would demand. But I think probably here, the most useful thing we can do is, you know, require, you know, some level of disclosure, and hope that we start some level of conversation, or require some level of conversation between the therapist and the kid and family, you know, and make sure that people are aware that, you know, if there's a problem, this is where you can take it.
Well, this is Brad. I definitely think the language that's being proposed is a step in the right direction. I mean,
this is White, and I just I think that it's a good first start, definitely requiring a policy in place. I did just want to point out, though, with that Ethics Code 7.0, this is a little bit more about, like, the behavior analyst's responsibility to their colleagues, and when you're noticing ethical violations, reporting them. So while that definitely is applicable in this conversation, it doesn't give us specifics about, like, when you would want to use restraints, which would be in those instances where the safety of the client or the provider was at risk. So just clarifying that it's not that specific for what we're looking at.
This is Brad. I mean, the Senate Bill 963 that was passed last year for the use of restraint seclusion in schools says restraint may be used on a student in a public education program only under the following circumstances. The student's behavior imposes a reasonable risk of imminent and substantial physical or bodily injury to the student or others, and less restrictive interventions would not be effective. So that's pretty darn concrete and clear for school-based professionals. You know, I find that instructive and helpful in supervising staff. So.
So this is Sylvie. I think, like I said, I think that this is a good start to get in place so that it addresses some concerns that we've had. And then knowing what ends up happening with Senate Bill, 710?
Yes.
We might be able to later reference whatever 710 law becomes and adopt that, because that should be some clarity, or anyways, we can work on that some more once we know what's going to happen with it. That doesn't mean we're done with this conversation in any way, shape, or form, but I think this is a good rule to get in place for now, as long as everybody feels comfortable with that. So I'm not hearing any opposition.
We can't see each other's faces. That's part of the challenge.
I know, it's hard. And I know a way I can, so I'll just go down, so I have your names written down, and I'll just go down the list. Corey, do you have any issues or concerns with us moving forward with this?
Thank you.
You're welcome. Samantha, do you have any issues or concerns with the way that we've worded this and moving forward?
No, I don't.
Okay, Marie.
No.
And we've heard from you, Brad, but Brad, do you feel comfortable with moving this forward now?
I do. I think it's a good start, and we, can always revisit.
Absolutely, absolutely. And Megan, how do you feel?
I don't have any problem with it. I think we should move forward.
Okay. And Brenna, are you comfortable with how it's worded?
I am.
Okay, perfect. So, on the next page of your materials is a rule schedule. So obviously today is January 22nd. So today what we would like to do is to adopt proposed rules. We may, so this list here says that we adopt it, and then Ann has to do a few things. So then there's the open for public comment and all that stuff, and then you guys will review the public comment in July, which will be your next board meeting. And by then, we should know a whole lot more, because, well, for one, by July 16th, legislation will be done. So we'll know a whole lot more about those other two bills, the ones that Paul's going to talk about here shortly, and then also about Senate Bill 710. So at that meeting, you may have to open rules again, depending on how those bills move forward. So, but as of right now, in order to get this rule in place, you would have to adopt the amended proposed rule and this rule schedule. But if anybody has any questions, now would be the time to ask. Okay, well, in hearing none, if somebody would like to make a motion to approve the amended rule and the rule schedule.
This is Brenna, so moved.
And a second?
Farnham, second.
And who was second? Sorry.
It's Farnham.
Okay. So Megan, you have to do roll call again every time they vote in order to get them to vote.
Okay. Brenna Lagarde.
Aye.
Brad Hendershot.
Aye.
Corey Strong.
Yes.
Maria McMahon.
Marie McMahon, aye.
Jennifer White.
Aye.
Samantha Parnham.
Aye.
And this is Megan Johnson, I say aye.
Perfect. Thanks, Megan. So that was item number 3. So now we're on to item number 4. So Bob, get Paul on the phone. It's his turn to chat, and so we'll make sure that everybody can hear him. And in your materials, board members, should be the 2 bills. So it's a couple pages after that rule schedule that we just looked at. You should have Senate Bill 355 and Senate Bill 358. And then also the material should include a write-up that Paul did so that you can kind of follow along with what he's going to talk about.
Paul, are you still on the phone?
Bob, can you make sure, is Paul listening?
Yes, he's listening. He's still on the phone. And Paul, can you say hi to the board and make sure they can hear you?
Hi, this is Paul Terdal.
Can the board members hear Paul?
Yes.
Yes.
Great. Okay, so again, this is Paul Terdal, and I'm a resident of Northwest Portland. And this is really a follow-up from the discussion that we had in July, the July meeting, and a year ago in the previous January meeting. So the two bills that were filed were basically really followed directly from our discussion on my testimony in the July meeting, if you can sort of remember back to that. So the first bill, Senate Bill 355, is extremely short, and it simply postpones the sunset date on the Autism Health Insurance Reform Bill, which established some rules and processes for commercial insurance coverage of treatment for autism, including ABA therapy. That bill currently, Senate Bill 365 from 2013, currently is set to sunset a year from now on January 2nd, 2022. All we're doing is we're just postponing that sunset date by 8 years until 2030. As I discussed in July, I don't think we actually need that anymore because we had a very clear ruling from U.S. District Court and from some bulletins that the Insurance Commissioner put out in 2014, specifying coverage of ABA services and other care under the Oregon Mental Health Parity Act. But I think the simplest thing to do is to simply extend the bill that we have now, and then in the future, work on either making it permanent or sort of addressing some various conflicts with federal statutes. So I think that is straightforward, path of least resistance. I'm expecting it to be easy. Let me go ahead and talk about Senate Bill 358, and if there are any questions, then I would love to address those. Senate Bill 358 is, I think of it as a housekeeping bill that is intended to address just a number of small glitches and quirks and technical issues in the regulation of ABA and your licensees. These are basically things that sort of came to my attention either over the last couple of years through my own research or advocacy or sort of things that people have brought to my attention with questions. And it's really around lining up how your licensees are regulated, with their peer professions and say psychology or LPCs or LCSWs or things like that. So as an example, child abuse reporting. I think we all think of and assume that behavior analysts are required to report child abuse. Oregon statute on child abuse reporting is remarkably specific. It lists exactly which professionals have to report child abuse, and behavior analysts are not currently on that list. So this would add them to that list. Similarly, Oregon several years ago adopted a bill to prohibit basically gay conversion therapy for minors under the age of 18. And it specifically identifies psychologists and occupational therapists and some other professionals. It doesn't specifically refer to behavior analysts. And while I think it is probably broad enough that it would already apply, it is, I think, much better to be specific and clear. Another one is, this one was brought to me by another advocate who was a student at Lewis and Clark College who was doing some research for a paper. Duty to report unprofessional conduct, arrests, and convictions. I think that actually came up in the discussion you were just having because there was a similar language in the BACD code. But Oregon has a federal statute on this, and again, behavior analysts were not included in that statute. The fourth piece is on a statute on rights to behavioral health treatment without parental consent. This is a Oregon law that applies to essentially every other form of behavioral health professional other than behavior analysts, that would allow youth as young as 14 to seek treatment without their parental consent. The practical effect of this, as I have seen it applied, is really less about, I guess I don't really expect a 14-year-old kid to contact a BCBA and say, hey, I want ABA therapy, don't tell my parents. or my parents don't approve, but I want it anyway. I don't really expect that to ever happen. The practical effect that I see from it, from how I've seen it used, is that it permits the therapist to have a direct relationship with a teen, in which that teen then has a much more direct role in making decisions about their therapy. So for instance, with a psychotherapist working with the teen on improving the treatment plan and their goals. With an ABA provider, this could be having the teen sign off on their behavior change program and be specifically engaged in making decisions about this. This does not require that the teen be the primary signer, but it does permit that. And so I think that is useful, but I think it's something I'm certainly open to discussion on. The fifth piece changes the title from registered behavior analysis interventionist to licensed behavior analysis interventionist. I would emphasize this changes the name of the title only. It does not change any other requirements about licensure or anything like that. It's just the name. In my letter, I outlined several reasons for it. One of them is that Oregon has requested a Medicaid state plan amendment that would allow schools to be directly reimbursed by Medicaid for ABA therapy services delivered in school, provided that they are done by a licensed professional. And we could certainly argue that a registered behavior analysis interventionist is already licensed and therefore already covered. Changing the wording in the statute would just remove that ambiguity and would make it clear that a school could get directly reimbursed by Medicaid, for ABA services in school. There are also some other statutes out there, like Oregon's mental health parity law, that refer to services from licensee, people who are licensed or certified, but don't include the word registered. And so I think having clarifying that when we said registered, we meant licensed all along, and by fixing the name of the title, it gives better alignment with those other statutes. The next point on the enforcement authority, there are minor glitches and things in the code for enforcement. So as an example, under ORS 676.820, it is illegal to use a title of licensed behavior analyst unless that title has been granted. Nothing in the statute actually gives the Health Licensing Office any authority to enforce that, and there is no penalty for noncompliance. So this would basically, we're fixing that to make sure that, yes, actually, you really can't do that, and the Health Licensing Office can take action if you use that title without, that hasn't been granted. And then the last point that I have in here is really just sort of codifying the current practice. So as a matter of practice, the Health Licensing Office staff consults with you about any enforcement actions. Nothing in the statute even suggests that they should do that. When we originally created this board in 2013, the board had complete authority over everything. So the staff couldn't even issue a license to somebody unless you got together and voted to issue it. That was cumbersome and it had huge delays. So in 2015, we fixed all of that to give the staff authority. But we probably went slightly too far because the way it's currently now, you don't technically have any role at all in enforcement. All you do is you approve the rules, and that's it. And doesn't really make sense. It's not really the actual practice. So what this does is this basically codifies the actual practice, where it says that the staff needs to consult with you regarding enforcement issues. And then finally, Senate Bill 358 has the same language as Senate Bill 355 regarding delaying the sunset date from the insurance mandate. So if 358 passes, 355 would then be moved, and we would not need to move it. There are a couple of things in here I listed in the email that are going to have to be fixed by amendment. They're basically typos and things that we didn't really catch in time for filing. I'm not going to go through them. I think they're pretty straightforward. But I'd be happy to answer any questions, and certainly if you see anything, I would love to hear about them so we can fix them. There's a bill that we're not doing, I wanted to bring up, and that would be a practice act. So 2 years ago in Senate Bill 135, and one of the amendments, we tried to clarify that providing ABA therapy for the purpose of treating a mental health condition isn't legal, and to give health licensing some authority over that. I'm not doing that at this time because I think there's still some issues, and I think there would be some controversy, and I was hoping for a relatively straightforward bill that we could get through. So I do think it's something that's going to need to come back next time. I think it is already illegal in Oregon to provide mental health care without a license. And it's just the problem right now is that the authority for that rests with either the Board of Medicine or the Board of Psychology. And the Board of Psychology, frankly, doesn't want to do that. They would really rather you take that on. What would be helpful in the interim, and this is something we discussed in the last meeting, and I discussed it with the Board of Psychology also, would be if you could get some type of letter or statement just reminding people that practicing any sort of therapy, if it is done for the purpose of treating a mental health condition, is not legal in the state of Oregon. This is use of ABA for a non-medical purpose, like teaching, or say in a prison, for instance, for maintaining discipline in a prison, as long as it is not being done for the purpose of treating a mental health condition, that's fine. That's not illegal. But what is illegal already would be providing ABA therapy as a treatment for the purpose of treating a mental health condition. That's already illegal. I think just getting that clarification out, I think, would be very helpful. So those are my basic comments. Do you have any questions that you would like to discuss? Any issues you'd like to raise? Anything I can do to clarify?
I think the bill is great. I'm with Paul. There are areas in which we need to go further, but I think it's important to get a bill through. I think a lot of these issues are, not controversial and important.
Thanks.
This is McMahon. I agree.
Yeah.
This is John. Thank you for doing this, Paul.
Thanks. I will be meeting with Araba on Monday.
Say that again, Paul. We didn't hear you.
I was just going to say, I will be meeting with Araba on Monday, and I have also reached out both to a number of BCBAs within Oregon as well as to some of the national associations.
Perfect.
Any other questions or concerns?
Well, Paul, thank you. Thank you very much. We will obviously know a lot more by the next board meeting, so we'll probably have you, depends on how things go, but we'll most likely have you on the agenda again and to give an update of the specifics. Probably these two bills, and I'm assuming you're also going to watch Senate Bill 710, the one that just came out. So, we'll be in touch.
Yeah, I look forward to speaking to you in July. Thanks.
Thank you, Paul.
Thank you, Pat.
Okay, I will go ahead and disconnect.
So, Bob, we are on item number 5, which is public interested parties feedback. Is there anybody on the phone besides Paul? Well, Paul's not on the phone anymore, but is there anybody on the phone?
Anybody else on the phone would like to make public comment? Hearing none.
Okay, Megan, so there's no need to read your script for the public comment because there's no public comment. Paul actually had was on the agenda, so that was not the public comment. I mean, obviously it was public comment, but it was very specific to Paul. So we can skip number 5. So if you are ready, you can read the script for the executive session.
The Behavior Analysis Regulatory Board will now meet in executive session pursuant to ORS 192.660-F and ORS 676.595 for the purpose of considering information or records that are exempt by law from public disclosure at 11:04 a.m. on January 22nd, 2021. Representatives of the news media shall be allowed to attend the executive session by conference call and will be provided further call-in instructions shortly. The public phone line will be muted for the duration of the executive session. Are there any representatives of the news media on the public phone line?
No.
Recognizing that there is no news media in attendance, the public phone line will be muted for the duration of the executive session. We will return to open session before taking any final action or making any final decisions. We are now in executive.
Okay, Bob, are we ready?
Good? Yep.
Yep, okay. It is proposed that in case number 18-9094 to issue a notice of intent of revocation on the license and to assess the cost of the disciplinary proceeding up to $5,000. We need a board member to say so moved.
This is Brenna, so moved.
This is Brad, seconded.
Megan, you have to do your roll.
Yep. Brenna Lagarde.
Aye.
Brad Hendershot.
Aye.
Corey Stump. Aye. Marie McMahon.
Marie, you're on mute.
Sorry about that. Aye.
Jennifer White. Aye. Samantha Parman. Aye. And Megan Jones says aye.
Perfect. Thank you, guys. It is proposed that on case number 19-9213 to issue a notice of intent to suspend the license through the successful completion of the probationary period associated with the criminal conviction, and also to assess the cost of the disciplinary proceeding up to $5,000.
This is Brenna, so moved.
This is Brad, seconded.
I'll now call roll. Brenna Lagarde. Aye. Brad Hendershot.
Aye.
Corey Stump. Aye. Marie McMahon. Aye. Jennifer White. Aye. Samantha Parnham. Aye. And Megan Jones says aye.
Excellent. Okay, so those two pass. Now we're on the agenda under item number 8, which is other board business. Is there anything that we have not already talked about that you guys want to talk about at July? So we've got, so far, we'll have the 3 bills. So we'll discuss the 3 bills that are currently in legislative session. We'll bring whatever cases that need to be reviewed into an executive session. But what else can you think of? Oh, we'll know more about the restraints.
We have the permanent rulemaking.
and said permanent rulemaking.
Permanent rules, and we'll talk more discussion about the finances, the difference between the 2 years of expenses. But is there anything you board members want us to make sure that's on the agenda?
This is McMahon. Should we be talking about a letter regarding practicing without a license as was suggested? I think right now, since psychology has that sort of oversight, they'd like us to have that oversight. Paul has suggested, creating a letter. Should we be working on creating a letter of notice?
Yeah, so that letter, this is Sylvia again, that letter is on Heather's agenda. We were kind of on hold because of not knowing what would be and not be included in Paul's bill.
Okay.
Because the fact that, or I think originally the intent of Paul's bill was to include the Practice Act, and then obviously that's not in there, and so, but we don't know it may get added. Okay. So the less we have Heather work on your board, the less money you have to spend on Heather's work.
Okay.
So it is on her radar. She's just not working on it because we were holding off trying to figure out if it was going to happen statutorily, that she wouldn't have to do anything anyway.
Sure.
So that's kind of where we're at.
Okay, thank you.
Of course. Anybody else? Okay, well then Megan, you should have a closing script that you can read.
The Behavior Analysis Regulatory Board meeting is adjourned at 1:25 p.m.